like that. Because that's what we need right now. So the future right now is not what you did individually. I think the future is being an example of civil discourse and making decisions that benefit the people. And unfortunately, look, the way things are going, you guys are going to have up close and personal opportunity to impact this and show us, because it's going to be a mess in the next 6 months. And I'm glad that you guys are the ones. And my only hope, the only reason I can sleep in this crazy political time is that hopefully it lands on your desk at some point. And I know you guys will get us where we need to be. So thank you very much. I appreciate it.
Thank you very much. I really appreciate that, Secretary. So we have about 6 minutes left, which is not much time. I had a bunch of things that I wanted to talk about in terms of the impact and the significance of all this, but I think I'm going to jettison and pick it up where Secretary Wetzel left it, and I'm going to ask our two justices, what's next? This is a real window into the Supreme Court in 2022, and I think all of us are really blown away by the breadth of what you're doing, and I am really sad that we couldn't hear more, but I thank you for the invitation to go on the court's website and read about all you're doing. There was a reference to finances, which is challenging, and so I just wonder, can you keep doing more? Is there something on the horizon? Professor Chanitson, you're looking over at me. Do you want to weigh in for a minute before I give this over to the justices?
I'm just paying rapt attention.
Okay, all right. Then I'd just be interested, and I'll start with you, Justice Dougherty, and then to our future Chief Justice. Taking all of this exciting work you're doing, like, how do you keep it going, and what's next?
We're used to being poor. And the reality is you learn to do with what you have, and you learn to lean on the volunteers and the intelligence and the sweat equity of lawyers and fellow judges and system partners. And I think through maybe breaking bread, sharing a cup of coffee together, and really listening, you'd be amazed at what can develop and what you can nurture into something successful. But it's all ideal. Now, candidly, from an administrative perspective, what you're always looking to do is leverage. We'll say to our hypothetically speaking, we divert X number of money, we saved you $54 million. Is there any way that we were able to, instead of that money to go into the general fund of the state, is there any way we can, siphon some of that money or expend that money for a new program or reinvest in the use of electronic monitoring or GPS devices if the purpose or the thought is we have to reduce incarceration costs. But it really is a negotiation, and it's based upon relationship. As everything else in life, it's based upon relationship.
Justice Todd?
Well, I'm at the same time optimistic about what we do and discouraged about the funds that we have to do it. All of the programs that we have, whether elder justice, treatment courts, taking care of children, all of those programs and specialty courts require funding to some degree or another. And believe me, we use volunteers in a way that I can't even express how thankful we are for the volunteers, judges, lawyers, laypersons, experts who, the hundreds of thousands, perhaps millions of dollars we save in consulting fees because people care about these issues in Pennsylvania and people are willing to donate their time. That saves countless dollars for Pennsylvania taxpayers, but the bottom line is programs do cost money, and specialty courts are funded largely by the counties and their own common pleas court systems, and of course the state court system funds these programs as well. But we're talking about programs like the vet court program that not only saves the state money, it has a tremendous impact on recidivism. And it takes individuals who have honorably served our country, to whom, in my opinion, my personal opinion, we owe a debt of gratitude. And when they come back from Iraq or Afghanistan and they've suffered from PTSD or traumatic brain injury, and they now have drug and alcohol addiction issues, and they've fallen into the criminal justice system, I believe that we should do everything we can as Americans and as Pennsylvanians to try to help them get back on track. And And our treatment courts do that. And the vet court model, where we have a judge who is serving as almost their commanding officer, we have vets working together like they're in the service again, helping one another through the program, participating in a 2-year program where they get treatment and they're held accountable, and they go back into the community without having to go to prison and become Secretary Wetzel's problem. And they go back into the community, they're reunited with their families, they become drug and alcohol independent, and they have jobs again, and we've restored them to the lives they had before they went into the service. That is something that is worth, that's worth more than money could ever pay for. So when I look at the accomplishments that we've made, but yet the challenges that lie ahead, I think that the judiciary's budget is something that we really need to focus on in the future. And I have to tell you, these issues that we work on are not partisan issues. All of the legislature, all of the executive branch, all of the justices and judges will agree that these are important nonpartisan issues. We all want to help children. We all want to serve elder justice. We all want to help people who need help with drug and alcohol addiction or need treatment courts. These aren't controversial issues, so they shouldn't be partisan issues. And when it comes to budgetary issues, I just want to point out that the judiciary consumes 0.5% of the state budget. Is that correct?
I would lean on Justice Donahue. She's the one who knows that.
Is that correct, State Court Administrator Moulton? That's correct. 0.5%. And yet, under our system of budget in the legislature, the judiciary has to go hat in hand, to the legislature to beg for money. As a co-equal branch of government, I don't think that's the correct way to address this. And the judiciary works hard and does a lot for the Commonwealth, and I think that that should be reflected in our budget.
Well, thank you both for those concluding comments. This symposium has stimulated our minds by giving us so much new information to think about, but also has brought a warmth to my heart. I'm enormously proud of this court, and I want to thank all of you, not just this panel, but the rest of the members of the court for the work that you do. Thank you for sharing the modern Supreme Court.
Before you stand, and thank you, we're going to take a break, but before we go, we have a tremendous panel coming up next. Judicial decision-making in State Supreme Court, Third Circuit, Honorable Cheryl Ann Krause is the moderator. And we have Chief Justice Baer, Chief Justice Beatty, Chief Justice O'Connor, and Chief Justice Sattel. So let's come on back maybe in about 10 minutes, and we will hail to the chiefs. as the official cat herder of the 300th anniversary, I don't take it personally. And welcome to everybody out there who's listening through live stream. So I'm going to ask that people begin to slowly head to their seats. Ben Bear and Steve Wigreiser, if you could help herd the cats in the back into the front, that would be a great help. Ben Bear. You could help Mr. Wigreiser herd those. I know, I was always the one that sat in the back of the classroom. Justice Mundy is asking, and Justice, perhaps you can mandamus them to the front of the room. Okay, here we go, and thank you.
Need everyone to sit down. We have our chiefs from 3 jurisdictions who traveled very far to be here with us today, have to leave to catch trains to be home for various obligations. So we're not flexible on the back end. Let's get going on the front end. Thank you.
It's my honor to introduce the Honorable Cheryl Ann Krause. I think when you ask someone, as I did, what would you like me to say about you? Her response was, I'm a mom, I have 2 young kids, I'm from a military family, and my husband's in the Air Force. And I think that tells you about what she holds important. A little bit about her background. Both of us attended, actually, the University of Pennsylvania. She majored in English. I majored in Smokey Joe's. Yes, for those who've been there. Thank you. She was appointed to the U.S. Court of Appeals for the Third Circuit, and I think perhaps the most telling statistic about her and her career and the respect that she's held in is that she was confirmed 97-0 by the United States Senate. And which is quite remarkable. She's a graduate of Stanford Law School, then clerked for Justice Anthony Kennedy of the United States Supreme Court, served in the U.S. Attorney's Office for the Southern District of New York. She's a lecturer. She's an adjunct professor at Penn Carey Law School. She's an author, and her law review article, Lawyer Wellbeing as a Crisis in the Profession, won the Warren E. Berger Prize, and it shows you her concern about lawyers and their well-being. The Honorable Cheryl Ann Krause.
Thank you, Bob, for the very kind introduction, and to Chief Justice Baird, to Justice Mundy, to Chip Becker, and the committee for putting this remarkable symposium together and giving me the opportunity to get to know so many colleagues on the state bench. This is also a really remarkable time to be on a state Supreme Court, to be on a state court anywhere. We have heard over the course of yesterday and today about some of the changes over history. And many have said, and I'm sure all here are sensitive to ways that the challenges that we're facing now as judiciaries, both federal and state, are, and perhaps as a country, are in many ways unprecedented. Challenges that we face dealing with social media, with our role in the world, with civil discourse, and even our identity and values as Americans. But there's an infrastructure that our founders put in place that has guided us through these past 250 years, and that we can hold on to tight. That is one that has gotten us through the swings that we've heard about. Sometimes swings even in the mind of an individual justice, like Justice Gibson, who changed his mind about federalism, as we heard yesterday. And through the Warren Court, Rehnquist, and the swings that we're experiencing now, as we've seen decisions come out of the United States Supreme Court, like Rucho versus Common Cause, like Danforth versus Minnesota, giving state courts the authority to provide remedies for federal constitutional violations greater than the federal courts. And of course, with the preview that we seem to have gotten with Dobbs versus Jackson with Women's Health. There is a spotlight that is coming back to the states. And that makes it particularly exciting to have a panel like this one, where we get a perspective from a number of state courts and from leadership in those courts. We're going to see how much time, how much we can fit into the time that's available today, but among the topics that we intend to cover are the this panel is about decision-making in the state courts. And we'll start with some of the ways that the docket may be changing, and think about the decision-making in terms of constitutional interpretation. We will look at statutory construction and roles of canons there, the role of the dialogue, that conversation back and forth with the federal courts, with some of the formal ways that happens, like certification, and some informal means of communications. And finally, think about some of the politics, ways that politics of necessity informs how folks come onto the bench in the states, what that means for public perceptions about the independence of judges, and think about how it relates to the culture and collegiality of our courts. Those, of course, are issues that are of concern to both the federal courts and state courts, and a dialogue that we have had and will continue to have as we work through those issues. Very briefly, we have all heard wonderful things about Chief Justice Behr, and with thanks to his partnership across the street, I know from the entirety of my court, we're so pleased to have him now as chief since April of 2021. We also have with us Don Beatty, Chief Justice of the South Carolina Supreme Court, who has been in public service in myriad ways through his career. Also from the military, a commissioned officer in the U.S. Army, and a former member of the House of Representatives, and has served as a trial judge, a Court of Appeals judge on the Supreme Court, and chief since 2017. We have Maureen O'Connor of the Supreme Court of Ohio, who likewise has much experience both in the different branches of government and across the courts. As Lieutenant Governor, she led the anti-terrorism initiative post 9/11, including working closely with Department of Homeland Security, and she served at all levels as a practitioner, as a prosecutor, as a magistrate, and common pleas court judge. She was elected in 2002 to the Supreme Court of Ohio and became their first woman to lead the Ohio's judicial branch in 2010. She is also past president of the National Conference of Chief Justices and the former chair of the National Center for State Courts Board of Directors, which takes us to Chief Justice Paul Sotell of the Rhode Island Supreme Court, who is currently serving in both of those posts, and who also has experience serving in the House of Representatives for his state, both as a representative and also as minority leader. He's had some exposure to federal elections as a delegate to the Republican National Convention in 1988, and joined the Rhode Island Supreme Court in 2003 and has been chief since 2009. So with this wealth of experience and perspectives, I'd like to open thinking about this shift from the federal Constitution and federal courts setting the floor to the offer made with these kinds of decisions to the states to set the floor. And let me start with you, Chief Justice O'Connor, in terms of the consequences for the docket and for the ways you think that may change the approach to state constitutional interpretation.
I'm sorry, would you repeat that? I'm having trouble hearing you.
I was saying with this shift from the focus on the federal courts to the state courts in terms of an opportunity to set the floor for individual rights. How do you anticipate that affecting the docket of your court and if at all, the approach that your state courts take to constitutional interpretation?
I don't know that I would think that it will affect our docket as far as volume goes, the type of cases. We've had cases, ever since I've been on the court, that actually are requesting that the state Supreme Court come to different conclusions than the United States Supreme Court with the same problems, the same issues that have been presented, and whether or not the United States Supreme Court decision will be the guidepost for how the state court will decide a case. One of the cases that I was involved with in 2000, just by way of background, 2005, the Kelo case, Kelo versus the City of New London, United States Supreme Court held that economic development satisfied the public use limitation in the federal Constitution, but noted that state courts may reach a different conclusion. Well, we did. We had the Norwood versus Horney case that was a case where we decided that economic development was insufficient standing alone, was insufficient to allow for taking of the property in Norwood, Ohio, which is a little community outside of Cincinnati. It was a long, drawn-out, circumstance. The entire landscape looked like the landscape of the moon. They had purchased all of the property except for 4 property owners that held out. There were no services to their homes. There were no electricity, so all that was taken away because every house was raised surrounding them, and yet they would not allow for their property. They fought for their property. And the Ohio Supreme Court came to a conclusion that was diametrically opposed to the rationale of the Kelo case, where economic development alone is insufficient. There was a void for vagueness, a component to our case because of the definition of a deteriorating property, which was going to be the underpinnings for government taking. So to make a long story short, we in Ohio have experienced cases, decided cases that, like Kelo, are not in keeping with the rulings of the United States Supreme Court. We've found the application of the Constitution, Ohio Constitution, affords greater protection. And that is always the underpinning for my starting point when I'm looking at a case that asks us to deviate from the United States Supreme Court's precedent. I look to the amount of, I look to what is being asked. I look to the protections that are requested. I look to the social order, obviously any statutes that we have and precedent. And that's my starting point.
So there's, as you've described, there's room to do that with property rights, with concepts of void for vagueness. One of the areas we touched on yesterday was in the Fourth Amendment and how privacy interests seem particularly ripe for larger interpretation in the state courts. And Chief Justice Sattel, Rhode Island is certainly a state that has given greater privacy through its state constitution. Can you talk a little about the background to that, how it came to be, and how it's now administered differently?
Well, thank you, Judge. And let me first say what an honor it is to be here at this tricentennial celebration. Especially in this forum, the National Constitution Center. This is really awe-inspiring. And I want to thank Chief Justice Baer for inviting us and the members of his court and the Supreme Court and the organizing committee for putting this all together. It has been fascinating to learn about the Pennsylvania Constitution, and I can't wait to get back home. And when I see my friends on the Massachusetts SJC, I may burst a bubble or two with the information that I have. It has been very inspiring, so much so that when I return to Rhode Island, I plan to put together an organizing committee for our 300th anniversary. We'll not attempt to outdo you. It will be modest but appropriate. And I want to invite you all to attend in 2143. Now, how did we get so far behind Pennsylvania in development of our constitutional law? And I know we're a small state and easily overlooked, and quite frankly, in the area of constitutional law, it may be justified for various reasons. But if you'll indulge me for a few minutes, I just would like to give you a history, or at least our constitutional history, to show how there have been different developments in that area, and if only to put my comments this morning in some sort of context. Rhode Island was founded by Roger Williams in 1636, which is probably 1 or 2 generations before William Penn. but much like Penn, it was founded on the principle of religious freedom. Roger Williams was, as you may know, a leading proponent of that. And he founded a settlement that he named Providence in 1636, and then shortly thereafter, there were 4 or 5 other settlements that were developed in the area, Newport being one of them. And there was no centralized government. There was cooperation among those settlements, but no centralized government. So in 1643, Roger Williams returned to England to obtain a royal charter. It became problematic because England at the time was in the midst of a civil war, and King Charles I had lost a lot of his power, and he was soon to lose his head, quite literally. But Williams was able to secure a parliamentary patent, which gave some legitimacy to the colony and created a government. And it became somewhat, the legitimacy was under suspicion after the restoration of the Stuart monarchy. So we attempted to obtain a charter, and we did obtain a charter from Charles II in 1663. Now, this was a remarkable document in the amount of self-autonomy it gave to any government. I can't imagine there was a more democratic government anywhere. We elected the governor on a yearly basis, and the deputies, as they were called. Judges were elected on a yearly basis. Members of the General Assembly were elected every 6 months. It was truly so much so that it was criticized as being dangerously democratic, and I think it may have been eventually an impetus to the fellows that are in that statutory hall over there, that a Republican form of government was far better than a pure democracy. But in any event, Rhode Island was the first colony to declare its independence from England on May 4, 1776, fully 2 months before the Declaration of Independence. We celebrate May 4 every year as Rhode Island Independence Day. In point of fact, we renounced our allegiance to King George III. We hedged our bet a little bit on Parliament. I like to think that we were brave, courageous, and bold, but not entirely crazy. But in any event, the charter of King Charles II in 1663 remained our organizational and fundamental law for 180 years until 1843. We did not, during as Pennsylvania did in 1776, I believe, put together a constitution. We were quite happy with our government the way it was. And ever distrustful of a strong centralized government, we didn't even send any delegates to the Constitutional Convention. And we were the last state to ratify the convention, and then only by a 2-vote margin. So our history is very different. The charter eventually in the 1840s, early 1840s, it virtually imploded because of the rigid system of apportionment that it called for, which kind of gave permanent predominance to the rural interest over the mercantile, and it was a period of industrialization. More immigrants were coming to the state. And they did not have the right to vote because the freemen, the people that could vote, were obviously male at the time, and they had to own property. So we ended up in 1843 with an armed conflict. I don't know how serious the arms were, but there was some disputes, and eventually we ended up with 2 constitutions that were drafted in 1842. One, the People's Constitution, and then the government had its own constitution. And eventually that worked its way up to the U.S. Supreme Court and resulted in a rather famous case, Luther v. Borden, in which the court articulated the political question. So that is our constitutional history, much different than Pennsylvania, much different than most other states, I would imagine. And we adhere to the Fourth Amendment, but we articulate on many occasions that that we have our own protection, we have our own Declaration of Rights, and in several cases that we have indicated that we can find a principal rationale, we will depart from the interpretation of the Fourth Amendment. I have looked at cases, I can't find a principled rationale. All I can find is statements that say that the court, the U.S. Supreme Court says that states can afford greater protections, similar to Ohio. States can afford greater protections than are allowed under the federal Constitution. And one case that illustrates this fairly well is one that the more seasoned people here might recall. The younger ones probably would not have heard of it, but it involved Klaus von Bülow, a socialite in Newport, who was charged with 2 counts of attempted murder on his wife. His wife fell into a coma on 2 occasions. The first time she recovered. Second time she never recovered, and I don't think she ever recovered from it. But he was charged with attempted murder, and the trial was very interesting. Obviously, his wife's family, his wife's children, and became very suspicious. And there was a maid that testified, Maria Schrallhammer. Now that name and her personality is right out of Central Casting. She was the maid, and she discovered in von Bülow's New York apartment, in Mr. von Bülow's closet, a black bag, and inside that black bag was another black bag. And inside that black bag were 3 vials, one of which contained pills, one of which contained powder, and one of which contained liquid. And she checked it out a couple of weeks later. It was still there. Around Thanksgiving, which was several months later, she checked it again, and the vials were there, but also there were several needles, a syringe, and a bottle marked insulin. And she noticed that same bag a couple of weeks later amongst the belongings that the von Bülows intended to take to Newport for a Christmas holiday. And sure enough, on a few days before Christmas, Sonny von Bülow went into a coma again. And after they returned, the son, Mrs. von Bülow's son, hired a former Manhattan DA as a consultant. And his name, I believe, was Richard Q. And he hired a private investigator, and they went back to Newport to try to find that black bag, stopping first at a locksmith in Providence so they could get into it, but as it turned out, they didn't need it. In any event, they found the black bag, they took it back to New York, kept it at I think, Mrs. von Bülow's daughter's apartment, and made samples. They sent one to Richard Q's brother was a physician, so they sent some of the samples, some of the contents to him. He had them tested. The son made some samples. He sent them to another doctor. They were tested. And eventually they turned over the black bag to the Rhode Island State Police. And a week later, the state police took it to the state toxicology lab and had further tests done. Now, when they got to trial, the court admitted the results of the toxicology report. And that was the issue before the Supreme Court. And the Supreme Court did a very exhaustive analysis under the Fourth Amendment, determined that this was not a police search. This was a private search. It did not implicate Fourth Amendment. However, when they took the state police, after having the black bag sit in their evidence locker for a week and then took it for further testing, that was an expansion of the private search, and therefore it did implicate Fourth Amendment, and the results should have been excluded. Now, after going through all of that, the Supreme Court then said, well, we also find an independent ground under the state constitution. And they went through the analysis for that. Again, really the only underpinnings were the fact that the U.S. Supreme Court has said that states can afford greater protection, and also that Rhode Island had passed statutorily an exclusionary rule before the U.S. Supreme Court had articulated an exclusionary rule. So we do have an independent ground. We've used it on several occasions. We do not permit roadblocks for drunk driving roadblocks, again, relying on the Rhode Island Constitution for that. And also, with respect to wiretaps, we've said substantial compliance with the wiretap statute's not sufficient. It has to be strict compliance, and that has been grounded under our state constitution as well.
It's such an interesting and different history. Reaching back, you see how these state constitutions that really informed what our federal constitution is are subject to different interpretations, but also with that history, it really bespeaks also the sort of distrust of centralized government and the particular role of the judiciary. So let me ask, in South Carolina, for you, Chief Justice Beatty, because we heard yesterday about ways that working in the state, that there is perhaps built in a sort of deference to the legislature, or at least consideration of the legislature, even in interpretation of the Constitution. And we've also all been aware and talked yesterday about the concept of originalism as a philosophy, as an approach to interpretation of the Constitution. In your court, does this push toward originalist interpretation play the same sort of large role that it's now playing for the U.S. Supreme Court? And how do you navigate in your constitutional interpretation the role of the judiciary versus the legislature?
Interesting questions, all of them. But before I get started, may I honor my Southern roots and say good morning? To talk about, or even to be invited to this symposium was a godsend, if you will, a stroke of luck for me, if you will. I have, for the last 3 or 4 years, been trying to drag my justices, my lawyers in my state, into a corner where we would consider our South Carolina Constitution. And when I got the call or the letter from Max about participating, I said, well, this is an opportune time to learn how this ought to be done. I was here on yesterday, and I gained quite a bit of information from your panelists on yesterday, and some that I'm going to use. And in fact, I'm going to have a panel participate in South Carolina on this very same subject. So the state constitution issue is a big deal with me. And it's a big deal for more reasons than one. And currently, I would think that the reason is that the U.S. Supreme Court has actually restricted our rights in quite a bit over the last 15, 20 years. And I've noticed from resorting to our own Constitution that there's quite a difference. There's a little nuance here, little nuance there that would allow us to do certain things now that the U.S. Supreme Court has not allowed us to do in the past. Or if we adhere to their decisions, we won't be able to do now. But I gather we'll talk about that further on down the road. But as to deference to the legislature in interpreting our Constitution, well, quite frankly, we've not had many occasions to do that. In South Carolina, the only reference to our Constitution that you will see in our jurisprudence primarily comes from tax issues, disputes between the government and the legislature. Other than that, and there's quite a bit of that, by the way, but other than that, you won't see much reference to the South Carolina Constitution, other than mentioning maybe Article 1, Section 15, or Article 1, Section 8, but no real discussion about the Constitution. So that's why this is important for me to be here today. But your second question was, and I'm sorry, I've gotten away from it, but what was that?
Well, I was asking about the role of originalism and if that's a focus, but to the extent that the South Carolina Constitution has not gotten a lot of interpretation, then maybe the question's not really ripe.
Well, you know, that's a good discussion, talking about originalism, textualism, populism, all those things. Those are important things, but to be quite frank with you, I don't know if we all put ourselves, if you will, in either one of those little boxes. It depends upon what the outcome that we seek. And if the outcome is one thing and being a textualist will get us there, we'll do that, quite frankly. And if the outcome that we seek is something that say, well, maybe that's not really what we want to do, we want to go in another direction, well, we'll do that as well. So it depends.
So you alluded a moment ago to things that you've observed in your state constitution that are somewhat different and that open up for you, in your mind, the possibility of some different interpretations, particularly as there may be more leeway to do that going forward. Can you tell us about any of those?
Well, South Carolina is, and I'm certain all of you are familiar with my state to some extent, we have a different kind of history. We've had 6 or 7 constitutions, and we've been somehow pushed into doing each one of them. And we have, as a result, ended up with a constitution, in my opinion, that is different from most states' constitutions. For instance, when we talked about the 8th Amendment in the federal Constitution, cruel and unusual punishment. In South Carolina's Constitution, it's cruel or unusual punishment. And we tend to think the R makes a difference. So we are now engaged in some capital cases, death penalty cases, where that distinction is being made. And there are other instances that I think we're going to be able to discern some difference that's going to be important to us, and that is in the privacy area, abortion. Now, we've had abortion cases, quite frankly, over the years in our jurisprudence, but we have not had abortion in the way that we are going to see it, I think, in the next year, 2 at most. And the reason being is because South Carolina Constitution, unlike a lot of constitutions, we have a specific right to privacy in our Constitution. So we're going to use, as I envision it, talk about past cases from the federal side about the interest in the Constitution, what privacy really means, and that kind of a thing, and to say, well, the federal Constitution doesn't have a real right to privacy in it, well, that's fine. But we're going to use your rationale and your reason to talk about it when we talk about privacy. So it's going to be an interesting conversation and discussion and within the next year in South Carolina.
So hearing you talk about your state's history with a number of constitutions, really drives home one of the points that we heard about yesterday, how much easier it is to amend a state constitution. And when you think about the sort of approach to constitutional interpretation, the focus on originalism in part perhaps is because we have a constitution that is largely frozen in time on the federal side and so difficult to amend. And the concept of a living constitution, one that's evolving, is really much easier to digest in the state systems, where truly it is evolving through amendments and even new constitutions, as in your state.
I would agree with that because, like I said, we've had 7 constitutions, maybe 6, depending upon who you're talking to. But in each one of those, there was an evolution in our Constitution. Each one put something a little different in it that meant more to the people, gave people more protection. And I think right now we have, if we really delve into our Constitution, there's a lot of room to play there. Or fight even, if you want to say that.
Yesterday, Justice Waxman and Professor Gormley had touched on the Edmunds decision. And some ways where, at least to this point, and it sounds like with other state Supreme Courts as well, there has needed to be a justification to depart from the federal Constitution. Given where we are in time, should that change?
Yes. Professor Gormley had said yesterday that Edmunds was never to be a barrier, rather it was to be a construct for the enhancement of state constitutional rights. We have some jurisprudence that, frankly, I think we need to clean up. I look at all my colleagues there in the first row, which says that if you don't make an Edmunds analysis, you waive the issue. And I think that's imprecise. As I said briefly, if you don't raise the issue, preserve the issue, brief the issue, and argue the issue, you can't get a decision from us. We're not going to be your law clerks. You can't throw it against the wall and then ask us to take it from there. So I don't know that we should have said, and I did not go back and read these cases in preparation for today, that it's a per se waiver. It's more as I said, the generalized rule that you have to preserve. And again, I think that's probably true in all of our states, and certainly the federal jurisprudence. You have to preserve, you have to argue. The advantage to Edmunds is that it tells you how to argue these issues. You know, if you have a statute that gives you, in a criminal statute, 4 elements, it should be easy to brief. You take the 4 elements. You have a case that says you have to meet these factors to prevail, you do it. Well, in Pennsylvania, it should not be hard to argue the state constitution, because you argue the 4 points of Edmunds, which, you know, in the future we might refine as this becomes more prevalent. But if you do that, you won't be accused of a lack of preservation, briefing, argument, and you will get a decision. And Cheryl, I agree. I think that after the Warren Court perhaps seduced all of our state courts into complacency because it was so expansive in the rights, that the pendulum has now swung back. There's nothing wrong with that. The federal courts are not going to be expansive, at least the United States Supreme Court, in the preservation and protection of rights. I think we can. I think we should. I know for a certainty that the United States Supreme Court wants us to the most conservative, most of the most conservative. They're happy for the states to do this. They don't object to that at all. We have not done that. I don't think any of us have done that, and I think we do need to, and I think we can.
Obviously, a fertile area and one to keep an eye on in the coming year, with decisions coming down and years ahead. Let me ask about another area where the Supreme Courts are interpreting the law, and that is in statutes. One of the perhaps unique things, or rare at least, in Pennsylvania is that there is canons of statutory interpretation that have actually been codified. Mm-hmm. To what extent do you rely on those codified rules versus other common law rules that are in Pennsylvania? And then I'd like to hear from the other panelists.
Yeah, and I'll try to be succinct because we have Pennsylvania lawyers here who probably know this. I would say entirely, and I would also say, and again I think you all know this, that under our case law, our constitutional interpretation is also guided by our Statutory Construction Act, and that's very helpful. And I agree with Chief Justice Beatty. I think these various, with great respect to my colleagues on the U.S. Supreme Court, our colleagues, I think these schools of interpretation are falderall. I think they decide where they're going to get there. Sometimes the road is straight, sometimes it's crooked, but they're going to get where they want to go. I think the only interpretation that matters is get it right. And I think that the rules of statutory construction in Pennsylvania allow you to do that, starting with plain language, going to intent, and I think arrive at a good result. And they permit you to argue precisely what we need to decide. And I think that symmetry and that cohesiveness permits for a better result.
If I might add, Ohio has the same statutory embedded, the guideposts, I'll call them, for what the court, how the court should interpret, special or local provisions prevail, exceptions to the general provision. They have all that kind of guidance that they put in there, and I call it guidance because sometimes it works and sometimes it doesn't. But one of the things that is interesting, and I might add that we have a provision in our Constitution that every 20 years we have to take a look and see if we need a constitutional convention in order to, that's in the Constitution. Our last Constitution was drafted in 1912. So we have, that's the Constitution we're working with, is 1912. And just as an aside, I was reading the notes to, the minutes, they weren't exactly minutes, of what happened at that Constitutional Convention. There is a discussion about how weird it would be if we had a female Chief Justice. I kid you not. It was, can you imagine what it would be like to have a female Chief Justice? It's pretty hilarious and kind of precedent, that they were thinking along those lines. But when we have interpretation, constitutional interpretation, statutory interpretation, we have a division amongst our justices on the value of textualism, textualism and originalism, strict construction, strict compliance with the statutory constructs, and it depends a lot on the judicial philosophy of the judge, on how they're going to rule, how they're going to, and how they look at the problem that is preserved and brought to our attention, and what is in black and white on a piece of paper will, some of our justices will embrace the limitation placed upon the court. Others, based on judicial philosophy, will take the same issue on a case and go in a different direction and expand the rights.
So where you've got, particularly where you have rules that are codified, I wonder how you handle legislative history, and does that play any role in statutory interpretation?
It does. There's a section here that talks about determining legislative intent. If a statute is ambiguous, the court, in determining the intent of the legislature, may consider among the matters the object thought to be sought to be attained, the circumstances under which the statute was enacted. I'm not exactly sure what that means. The legislative history, the common law or former statutory provisions, including laws upon the same or similar subjects, the consequences of a particular construction, the administrative construction of the statute. I think E, the consequences of a particular construction, is what you were talking about, Chief Justice Behr, that you have to figure out what the consequences are and whether or not you want to get there. And that oftentimes is what happens.
Chief Justices Beatty and Sattel, with your states, how have you handled the, Scalia obviously has had a major impact and an evolution within the federal courts to lead Justice Kagan to say we're all textualists now, and to, in many cases, eliminate any reference to legislative history when there's federal statutory interpretation, or almost apologize for it if there is discussion of that history.
No, well, in South Carolina, we don't have codified rules for statutory interpretation. All of our common law, the kinds of things that we all do, and we have done traditionally. So we don't have those rules. As to legislative history, We do pay attention to legislative history, unlike Scalia, who says that doesn't mean a damn thing. It's what's on the paper if we follow him. But in any event, we do use it. We have conversations about it often, and in fact, our legislature often filed briefs with us trying to tell us what they meant, and we routinely send them back. Say, no, thank you. But, no.
Fascinating.
We don't have codified rules either, and I really think the theories of interpretation are somewhat irrelevant. I mean, we never discuss it. It's never like, I'm a textualist, although perhaps a prime example was our case on same-sex divorce. The majority said that this same-sex couple married in Massachusetts legally could not get divorced in Rhode Island because the word marriage, when the family court was given the authority to dissolve marriages, when the family court was created in the 60s, the word marriage did not have any connotation to same-sex marriage. It wasn't relevant. I wrote the dissent and said that, well, each state is entitled to set its own rules. These people were legally married. They ought to have an avenue to get divorced. So that's perhaps a different way of approaching the problem. We don't, I'm always skeptical of legislative history. We don't have reports outlining what people said on the floor debates or in committee hearings, and even that I'm somewhat skeptical. You only get one or two. Legislative intent is critical in terms of structure of the entire statute, how it fits in, so we do look at that. But we always start with plain meaning, plain language, and then you see if you want to get around that.
I was only going to add that I think we are all textualists. I think we have always all been textualists. I think we will forever all be textualists. If the language on the page is clear, that doesn't guarantee the result, because you can read it differently in the real world. But notwithstanding, nobody's going to look at that plain language and ignore it. That's not a judge's job.
One of the prevalent methods of looking at the legislation on our court is the use of a dictionary. Oh my God, we have certain opinions authored by a certain justice that the dictionary takes a very prevalent role in the rationale and what is being analyzed, and that allows for a very, very strict and constrained vision of, number one, I think the role of the court and the relationship with the legislature. I think it minimizes, oftentimes it minimizes the role of the court and elevates the legislature.
It doesn't. You mentioned dictionary. On my court, punctuation.
Oh, yeah. Oh, that's it too. Yeah.
Where you place the comma means a lot.
Yes.
Again.
And that kind of a thing. It's ridiculous at times.
We have often quoted, when I say we, I didn't write it, but quoted Gardner as the authority if you read Ohio Supreme Court cases, you will see reference to Scalia and Gardner prevalently.
And if my law clerks would hear, they would tell you the rules of bear, but I think the use of the dictionary, which I dislike as much as my colleagues, the use of block quotes, the use of deference, are all the tools of a lazy judge. Think it through, articulate it carefully, and get to the right result.
We're hearing how these formal categories of interpretation really have little sway. It sounds like in the ultimate decision that gets made. But lest our audience come away with the idea that that's because decisions are ends-driven, I want to step back because having experienced it, I have my own intuition about it. But I wonder the extent to which, and let me ask you, Chief Justice Beatty, to address, to the extent that when you're saying you just reach the right result and put aside many of these labels, to what extent is that because the decision-making that's going on is really a group decision rather than individual decision, which requires the coming together of people with a number of different philosophies?
I agree with that, actually. When I was a trial judge, I loved the fact that I was a trial judge. My decision was my decision. And I didn't have to talk to 4 other people and see if I could come up with 2 of them that would agree with me. But that makes it quite difficult. I think today is probably the only time you're going to hear any judge tell you we are outcome driven. We think about what the outcome ought to be and see how we can get there. You won't hear that too often, and we don't want to repeat it too often. But it is so true. We think about what is right. When I became a trial judge some 25 years ago, I guess, you were required to sit with one of the senior judges for a period of 3 weeks before you were let loose on society, if you will, in the courts. And one senior judge told me, he said, look, Don, he says, now, and judging is not an easy job, but it's not that hard. Use common sense. Do the right thing. And if you have not gotten reversed in about 4 or 5 years, then you're not a judge. You know? If you've not gotten reversed, you're not a judge. And because that means you've not done what you really feel is the right thing to do and how this case ought to have turned out. Well, it didn't take 5 years. Not at all, but I've always stuck by my decisions, and maybe once or twice in the last 25 years, I say, well, maybe I got that wrong, but not many.
You know, I don't know that I would label it outcome-driven. When you're looking at a case, and in Ohio, the consequences of a particular construction, you know, how that we have it right there, that is something that we are to be, you know, we are to consider. There's been times when I've had to agree or even write a decision that I didn't like the legislation. I didn't think it was fair. I didn't think it was necessary the way it, oftentimes those are criminal statutes and they involve mandatory punishment, something like that, or a case with an unintended consequence, but you have to literally write the opinion using the law, and there's no getting around what the law says. You can embed in your opinion a request to the legislature to look at the law and to, you know, amend it as necessary, and we would be, you know, sending that message. Sometimes it's in the opinion, sometimes it's in a concurrence, and it's joined by many of the you know, justices. But that's an important duty. I don't think you can just say, you know, we have to obey the statute, and here is an undesirable result, and just let that hang out there. I think it's important because we have, you know, in our legislature, 7 lawyers, I think, and some of them are receptive to what the court says, just some.
We have said at our conferences on more than one occasion, and I can't remember who originated this quote, but I'd love to do justice, but I can't. And we all face that. And we do the same as Justice O'Connor in terms of sending not so subtle messages to the legislature if we disagree with the statute. Or...
Yeah. I've done that quite often, actually, in concurrences or even a dissent, even in the majority opinion, where I've asked the court to go along with me about delaying the effectiveness of this opinion in order to give the legislature an opportunity to deal with the issue that I find concerning. And believe it or not, that worked. In fact, it worked just last week on a sexually violent predator registration act that we were having some issues with and not allowing an opportunity for a person to come off the registry. It was lifetime registration. And I wrote an opinion that said you can't do that. It's unconstitutional. But we're going to give you a year to correct the problem. But we're going to let this guy off. He's been on it 10 years. The psychiatrist and everyone as forensic psychiatrists that he's seen and say he's not dangerous. He's not apt to reoffend. But yeah, we do things like that. And to say that we're outcome driven, maybe I need to rephrase that and back up off that a little bit. I should say we abide by the law. And if there's a nuance or if there's a crack in there that we can utilize, at least me, if I can utilize it to bring about the result that I think is appropriate in any given circumstance, then I will do that. If the law doesn't prohibit what I want, it may not say exactly what I want, but that's what courts do, Supreme Courts anyway, we make law.
Mm-hmm. We had a very, I think, well-written, well-reasoned case on to deal with money bail. And the way the court ruled was that you cannot use a high bond as a substitute for a remand hearing. In other words, the person should not leave custody pre-trial, during the pendency of the trial, for a variety of reasons: flight risk, danger to the community, danger to the witnesses, danger to the victims, that sort of thing. You take that into consideration, and we have a statute, and it's the responsibility of the court or the prosecutor to ask for, to initiate that. But in order to circumvent that, judges will put $1 million bond on, someone who's not a flight risk, is not a danger to the community, committed a murder maybe, but it was a specific victim. It was not, the community that was in danger. But okay, make a long story short, we ruled that you can't use money as a substitute for this hearing when you're going to take away someone's right to bond by clearly placing an excessive bond on or bail on someone. So this created somewhat of a brouhaha, and now we have the legislature attempting to put a constitutional amendment on for this November that will do away with what we said in the opinion. Our interpretation, it's what the statute says, for gosh sakes. And obviously the Eighth Amendment comes into play. So there's going to be a statutory amendment, constitutional amendment, if they can get it out of the legislature, which I think they will. And so they don't just do a statute change for this. They go with a constitutional amendment to reverse one of our opinions. I don't know what to think about that.
And it just, I think, 2 points apropos of that. First, in terms of the legislative response, as we ponder these difficult cases, I so often think, I hope the legislature will pipe up and tell us what is correct or incorrect if we didn't get it right. We never get a legislative response to one of our cases unless we decriminalize something or reduce a sentence. Then we get a legislative response. But for that, we never get a legislative response. And I do think that's unfortunate. Under our rules of statutory construction, that means that we got it right. I think that's a fiction. I think it's that they just don't care much. And the other thing that I was going to say, and Maureen, I agree with you entirely. We in Pennsylvania, as you all know, have a Republican House and a Republican Senate and a Democratic governor. Well, the legislature cannot pass laws because the governor vetoes them. And I think 300-some vetoes in Governor Wolf's almost 8 years. And so what the legislature has done as a matter of tactics is when they want to do something that's a policy that the governor won't sign, they make it a constitutional amendment. I think that's dangerous. That's not the intent of constitutional amendments. I would hope that we could all, maybe next year, I can rise up and defeat those things on principle alone, that the way you pass a law is not a constitutional amendment.
So this really highlights the sorts of tension that can exist between a judiciary trying to interpret the law in ways that are objective, impartial, and our legislatures that are responsive directly to the electorate. But within the state systems, there are different ways of coming on the bench, and some of those also are answering to the electorate. And when there's talk of legislatures overruling a judicial decision, or even decisions being outcome-driven, it can raise the specter and concern about the role of politics in judicial decision-making. You know, at a time where, of concern to the federal judiciary as well, that the need to really reflect to the public the independence of this branch of government among the three, both in the states and in the federal system, is so critical to maintain a sense of legitimacy in our governmental institutions. I wonder if you can address, we have here among the states very different ways that judges ascend the bench, and challenges that you all are facing in perhaps as a result of that, and with the increased focus on the state courts on hot button issues where those sorts of politics may get in the way of elections or in legislative appointments of judges. How you're thinking about that and maintaining a sense of independence and legitimacy for your courts?
Well, in Ohio, we have very contentious judicial races, and we have races that are sleepers. And it just depends on the community, it depends on the county, it depends on, who's running. We have contentious races for the Supreme Court, of course. In fact, this year, for the first time, when you talk about politics, coming in, there will be party labels on the ballot for the Supreme Court candidates. That's never been done before. They're also going to have their party label on our appellate, our intermediate appellate courts. And that was by statute, passed by the legislature. And our legislature in both houses have super majorities of Republicans. Whatever the intent is, I'm not sure. I just know I'm not going to be on the ballot, so I don't have to. But here's my point and my advice that I give to all judges, no matter what court they're on. You have to do the right thing, and you have to stand up for democracy and rights, and do the right thing for every case that comes before you. And if it has a political consequence, and there's nothing wrong with recognizing that there's going to be a political consequence, and if you have to stand up and you have to take the consequence. That's all there is to it. if you don't do that, it's not only you, it's the entire branch that gets painted with a political brush. And I say to judges who are running, don't run if you're going to be devastated because you're going to lose. That's just not, this is not your game. This is not what you need to do. If you don't have a plan B that you're comfortable with when you lose your judgeship, which you know, it may very well do, don't run, don't get involved, because if you don't, I think that you're going to risk the danger of making decisions that are geared towards keeping you on the bench and not decisions that are necessarily constitutional, follow, you know, the statutes, et cetera. That happens a lot in high-profile criminal cases where you have issues. And if you are a judge and you follow the rules of bail and you put somebody on probation, that will be used against you on the local level. It will be used against you. But you have to do the right thing.
Chief Justice Satella, how do you manage the dynamics of politics and coming on the bench and judging in Rhode Island?
Well, we are appointed for life. Thank you very much. It's difficult for me to understand how it would be in a different system where you have to run for election, because you know we're not immune from public opinion. We understand public opinion, and you know you're concerned about it. But I think it's a lot easier for us to divorce ourselves from that and to make independent decisions. Without that, I mean, it's difficult, but that's, you know, just how we're going to do it.
Who makes those appointments?
We have a judicial nominating commission of 9 members. 3 are appointed by the governor, 3 are appointed by the president of the Senate, and 3 are appointed by the Speaker of the House. So you don't get politics out of the selection process. I mean, but any system, there are going to be politics, small p or capital P, in any system that you devise. But it's the commission then screens all of the candidates, they interview them, hold public hearings, and they will send 3 to 5 names to the governor, and the governor selects from those names.
Can you be impeached?
Yes, we could.
There is
yeah.
a pressure point there.
Yeah, and we have a judicial tenure commission that well, actually, they would recommend to the Supreme Court that a judge be removed.
So our founders obviously settled on that method to try to ensure the independence of the judiciary for the federal government. For Chief Justices Beatty and Baer, is it possible, where you don't have life tenure, to approach decision-making in a way that is truly independent?
As I indicated earlier, South Carolina is a little different. Our judges are elected, but they are elected by our legislature. So we don't have public elections. And Virginia is the only other state that has something similar to us. So those 2 southern states, if you will. But politics, very, very much involved. And let me be perfectly clear. The independence of the judiciary is in jeopardy. And if the independence of the judiciary is in trouble, so is our democracy. But getting back to the method of selecting judges in South Carolina, as I indicated, it's a little different. We have a nominating commission as well. Most of them are, members of this commission are legislators appointed by Speaker of the House, Speaker Pro Tem of the Senate, and with some 1 or 2, I think it's 3 lay members who they're not lawyers, by the way, the lay members. And you fill out your application, turn in all your financials, if you will. You take a written test, and then you sit for a public hearing. With the commission sitting on this table like we are, you're sitting out there with all your detractors sitting behind you. And they've sent in all of these nasty things about you, and you have to answer to each one of those. And then this commission selects 3 out of the 5 or 6 or however many that are offering for the position and send them forward to the legislature with a written report about you. And it could be good, it could be bad. But sometimes it really doesn't matter. They select who they want anyway. But politics, yes. Although we have this system, until recent years, it was not political. I mean, there's some politics and everything, but there was nothing that was just in-your-face political. People didn't ask you about your party affiliation. They didn't ask you about your views on certain things. That didn't happen. Occasionally it did, but not often. In the 25 years that I make reference to, that my tenure on the bench, things have changed. You have all of these little make-believe caucuses in our legislature. You were talking the Daddy Caucus, the Right to Life Caucus, you call them, you name it, there's those fringe groups, they're out there, and they have their little caucuses. And they insist that you come and sit down for an interview with them. And they ask you all of the questions that you see all these SCOTUS nominees dodge. You can't dodge those questions with this little group of people. And you have 4 or 5 of those that are very, very active, and they ask you all kinds of questions, how you will rule in this situation, how you will rule in this situation. And so you kind of try to dance around it, but no, they pin you down. Well, if you can't give me an answer, then I will not vote for you. And that happens, unfortunately. And it's a new thing in South Carolina. You didn't have that before. You do now. And even the judges on my court, I can sense sometimes a political leaning getting involved in a decision. And there was a reference here to controversial cases or matters that might come from the public, or matters might come to the court as a result of the public, if you will, that how you deal with those matters. Well, I have taken the tack recently on controversial matters that are in the news, and we have the case in front of us, and we're going to decide it. I have taken the tact of, before oral argument, making a statement that we are not a political body. We're not a soldier in your culture war. You may not like our decision, but our decision will be determined by the law. Now, 1 or 2 members of my court may not like that, but I'm the chief, I've said it. Is that? So what that does is, when we're talking about, we're conferencing the case and trying to draft an opinion, it kind of forced them away from those leanings. Not all the way, and they'll never leave all the way, but it kind of keeps them on track in the lane that we're supposed to be in. It has worked 2 or 3 times. I've only done it 2 or 3 times. And it's worked thus far, but whether or not it'll work again, I don't know. Courts are very political now, unfortunately.
Well, this has taken us just a minute or so over 12 o'clock. We're not going to go past the bewitching hour. I would just ask Chief Justice Baer to give you the last word here. And as we've heard from yesterday and today, the Pennsylvania Supreme Court, over 300 years now, has developed this storied reputation, has done so much for the Commonwealth. And much of that is because of its the respect that it's engendered from independent decision-making it's been able to make. How, with these kinds of pressures, do you persuade both the public and perhaps more importantly, other branches to treat the court with that kind of respect?
Oh, my goodness. Save the $64,000 question. I think well, let me do this quickly. I think that the principal attribute of any judge is courage. any judge, federal with lifetime immunity, Rhode Island with lifetime immunity, full-blown elections in Ohio, elections with retention in Pennsylvania. You have to make the correct decision every time, all the time, without compromise. And I think when you don't do that, and I'm not going to get into my fantasy world, but you turn to the dark side, from which there is no return because the lure of the dark side is too much. So you have to have courage. You just have to make your decisions. I've been told by members, and I'm a judge from the Democratic side, I've been told by recently by members of the Republican caucuses in the Pennsylvania Senate, we don't always agree with your decisions, but we respect you. I can't tell you what high praise that is, and how that pleased me. So I think that even if we lose a re-election in a state that re-elects, or if we lose retention, and the rumor is money is coming to get involved in Pennsylvania retention elections, if you've made the correct decision every time, all the time, hold your head up high and go on. And what you've done is, over the arc of history, you've protected the judicial branch. And let me just thank Judge Krause, who's been fabulous the whole time. And the greatest part of the Conference of Chief Justices was the personalities you get to know. And Paul, Maureen, Dawn, thank you.
Yes.
What a wonderful panel.
Yes.
We are going to break until 1 o'clock. Again, there's lunch downstairs. It's interesting that Governor Wolf, who helped start this symposium yesterday, the theme of his speech was reflection. And we are ending with the tremendous panel, Reflections from the Bench, featuring retired U.S. Supreme Court Justice Anthony Kennedy by video, the Honorable Brooks Smith from the Third Circuit Court of Appeals, Chief Justice Emeritus Tom Saylor, and the extraordinary Professor Pam Carlin. Let's try to get back here at about 10:01, and we're coming down the home stretch. Thank you.
Thank you. Thank you for having me. And well, thank you.
Are you leaving?
Everyone, please proceed to the second floor. The 1 p.m. program is about to begin. Once again, please proceed to the second floor. The 1 p.m. program is about to begin.
How we doing? Okay. And hello, live streamers at home. I know we have more than 100. So I'm going to ask that those in the back begin moving to the front. As we hurtle towards the finale. Thank you. Well, I have to tell you, I sort of have the same excitement that I have as we are about to hear, I would say, the encore. And so for me, I sort of feel like I'm at a Springsteen concert. He's gone off, and now he's coming back for the encore, and I know it's going to be great. First, you have seen now, this will be the 6th incredible panel, incredible moderators, and a journey through 300 years of the Pennsylvania Supreme Court. I want to thank Chip Becker and John Hare for having navigated, sat down, thought about how we could do this, put together 6 separate modules, linked them together, identified candidates and panelists, recruited them, spent many hours with them in advance going over what we're going to hear today. It will tell you very much what you need to know about John Hare, who said you should give Chip all the credit. And that tells you a little bit about John and his humility. I don't want to forget, for people who are here, if you take the CLE form with you when you leave today, it's downstairs. Fill it out, mail it in with your check, and that gives you, I think it is 8 hours of CLE credit. So thank you. So John is chair of Marshall Dennehy's appellate practice. He's handled more than 500 appeal issues. John has been on the other side of my cases for the last 25 years, as has Terry Sachs. And so I always welcome when they show up in the courtroom, because I know the defendant is worried if they are there. John and I spent 6 months together on the Salvation Army trial in the courtroom, with him on the other side trying to create appellate issues and me trying to avoid them. It was a game of cat and mouse. He was the cat, I was the mouse. John is the chair of the Pennsylvania Supreme Court Civil Rules Committee. He wrote the book on the Supreme Court. And I mean, he literally wrote the book on the Supreme Court, which was entitled The Supreme Court of Pennsylvania, Life and Law in the Commonwealth. And he's also written the book on the Superior Court, the keystone of justice, the Pennsylvania Supreme Court, 1895 through 1995. From those of you who saw the first panel and watched him talk about the early colonial period and the Pennsylvania Supreme Court for 15 minutes without notes, brilliantly and cohesively. He is a brilliant lawyer. He is, and I know him personally, humble, kind, and a great friend, John Hare.
Good afternoon. We literally waited 300 years for this, and it seems to have gone by so fast. And we do have a relatively hard stop at 2:30 for a couple of reasons, but I just want to take a moment to appreciate our MC. I'm going to turn the tables on him for a minute here. Bob described our courtroom experiences. You've seen for the last day and a half exactly why jurors love that guy, as annoying as that is. But throughout this process, he has been a coach, he's been an enforcer, which has been necessary on occasion, but absolutely tireless in keeping this program on track and largely responsible, along with his co-chair, Justice Mundy, for what you've seen over the last 5 panels, which I think are really tremendous. You've hopefully gotten that these are not sort of disparate, discrete panels. The idea is we're trying to tell the arc of the court's story, beginning with its early roots and through its work. And I was going to describe that for you in a little more detail, but then I heard Provost Professor Dean Epps do that for you, and I thought better of it. I will let the description that she gave stand because it's much better. But what we really want to talk about now is, as we've characterized it, reflections from and about the bench. A discussion from 3 jurists who have 108 years combined experience on state and federal courts, trial and appellate courts, and a professor who needs no introduction. You've already seen her, but took a sabbatical from Stanford Law School to go run the Civil Rights Division of the Department of Justice. And so we have tremendous tour guides on this discussion of the role of the judiciary, the rule of law, and what they mean in American life, and all the things that we've talked about. I first want to tell you kind of how this panel is going to work because it's a little unusual. You know that Justice Kennedy wanted to be here live. He had every intention of doing that, and it turned out not to be possible. So he very graciously came up here to Philadelphia to meet with us, and we videotaped a roundtable with this group and with Justice Kennedy. It's almost an hour long, so this is not optimal. It's about 59 minutes and 34, it's exactly 59 minutes and 34 seconds. And he has 17 minutes of introduction at the outset that is truly fascinating. We're going to play that video, and then we're going to continue the live discussion after that. I do want to do just very brief introductions. Justice Anthony Kennedy, of course, and none of these folks need introductions, but 30 years on the United States Supreme Court, 1988 to 2018, often the swing vote in some of the momentous constitutional decisions of our time. And I just want to take a minute to tell you how gracious that man is. He, as I said, wanted to be here live. He insisted, once it turned out he couldn't be, on coming to us. We'd have been happy to go to Washington to meet with him. So when he got there, this was 2 Fridays ago on May 5th, the Chief Justice had a lunch prepared for him and everyone else who was there. And we asked him, Justice Kennedy, do you want to eat first? Do you want to tape first? He said, whatever you guys want to do. And so we said, are there subjects you want to talk about? He said, you can ask me anything. And it was right on the heels of the Dobbs draft abortion leak. And so we said, is that something that you're willing to talk about? He said, absolutely. I think it's crucially important. And you'll hear at the end of his remarks that he addresses that in very passionate terms. And he had U.S. Marshals with him, and we asked him, Justice, what time do you need to be back? What time do we need to get you out of here? He said, I have a lifetime appointment. I'm in no hurry. An amazingly, amazingly gracious and a brilliant man, as you'll see. Speaking of gracious and brilliant men, Chief Justice Emeritus Tom Saylor of Pennsylvania was the Chief Justice from 2015 until 2021, spent 24 years in total on the court from 97 to 2021. And you don't need me to tell you this, but well known for the scholarly style and depth of his decision-making. Currently the scholar in residence at the Thomas R. Klein Center for Judicial Education at Duquesne University. And I must say, an absolutely amazing mentor to me for so long, and so many people across the bar and the bench, always willing to share his guidance and wisdom. So that is very, very much appreciated, Chief. Thank you. Next to my immediate right here, of course, Judge D. Brooks Smith, former Chief Judge of the Third Circuit, now a senior judge, been in the Third Circuit since 2002, 2016 to 2021 as the Chief Judge of the Third Circuit. He has a lot of other judicial positions he's held. It's incredible, and you're going to hear some of that on the video. The lobby of the federal courthouse in Pittsburgh was recently named after him. What an honor that is. And he's currently the Distinguished Jurist in Residence at Pennsylvania State University. Last but certainly not least, Professor Pam Carlin. I mentioned earlier what she's kind of moonlighting doing right now. Litigated lots of significant cases, argued many cases in the United States Supreme Court. And she gets the Most Congenial Panelist Award because you may know the Declaration of Rights panel, we lost our moderator on fairly short notice. And all of our first thought was to ask Professor Carlin, but then we thought, California law professor, Washington right now, you know, what would she know about the Declaration of Rights and the Pennsylvania Constitution? So we sheepishly asked her to do it, and she immediately said yes. And you folks saw how she moderated that panel. It's like she's been a Pennsylvania constitutional practitioner forever. So amazing, amazing group of folks to share their reflections from and about the bench. And so we're going to play the video now, and then we'll continue with the live discussion.
Thank you very much. It is an honor to be with you on this fascinating celebration of the 300th anniversary of the Supreme Court of Pennsylvania. This is a time in which we should understand the importance of courts, the importance of law, their centrality in protecting freedom, so that we can recommit ourselves to that idea, to that purpose, to that tradition. For a Californian, as Professor Carlin and I happen to be, 300 years sounds like a long time. California recently just celebrated its 150th year of being a state, and this is double that. But the reason California could become a state was because the Constitution of the United States, the commitment of this nation to freedom, the commitment of this nation to extending its blessings to all within its reach, had been preserved for so many years before we became a state. William Penn brought with him, both in a literal and a figurative sense, the Magna Carta. And let's discuss the Magna Carta for just a few minutes. You might say, no, wait a minute, we're talking about 300 years ago. Why go back 800 years? Well, the reason is because Magna Carta explains the nature, the process, the aspirations of law, the nature, the process, the aspirations of protecting freedom. There had been many fascinating legal proclamations in the centuries before Magna Carta. The Code of Hammurabi, the Babylonian Code, Solon's Law, the Law of the 12 Tables, the Justinian Code. Those all preceded Magna Carta. What's the big deal about Magna Carta? Because the Magna Carta was unique. All the codes just mentioned were the law coming from the ruler to the people. Magna Carta said, no, it goes the other way. The law goes from the people to the government, from the people to the king. It's the people's law. That's why it's called the common law. And there's an offshoot of that. It's also common because it makes common sense. The English tradition, which became the Anglo-American tradition, is that the law must always come from the people. But for that to happen, there has to be a rational, thoughtful, dignified, respectful discourse so that we can pursue the goal of freedom, so that we can seek the blessings of freedom as a community. The law comes from a community, and this protects freedom. There can be no freedom without order, and by order in our tradition, and in the tradition of the Pennsylvania Supreme Court, established 300 years ago, the order we are talking about is an ordered society, a society of decency, of dignity. And that is the Magna Carta that William Penn brought with him, both literally and figuratively. He had a copy with it, and figuratively he brought the idea of the Magna Carta to Pennsylvania. Courts protect this. Judges protect this. How do judges do this? Sometimes people will say, how do you decide a case? And one of my favorite answers is to quote from the first page of Benjamin Nathan Cardozo's book, The Nature of the Judicial Process, in which he puts forth this question. And he said, you think it would be easy to answer this question for a judge who's done it hundreds of times. He said, nothing could be further from the truth. Every case is different. How do judges go about deciding cases? It's a long process. It begins with the judge asking if this instinct that he has or that she has, this instinct to move in a certain direction, is principled and proper. We all have instincts, and for judges, the instinct is refined and more sophisticated over time as the judge understands more about the law. So the judge begins with this instinct, and one of the first questions the judge must ask is, who am I? In Hamlet, the very first line in Hamlet is, who's there? On the temple at Delphi, there's the ancient inscription, know thyself. So judges first must know who they are. How is it that they formed this instinct? And once they put the instinct into a principle, they have to then look at the principle. Is it rational? Is it fair? Is it thoughtful? Is it in accord with the law? Is it in accord with your own sense of decency and morality? Is it in accord with your idea of justice? Is it fair? And if it's someplace along this progression of thought, the judge has questions, he has to begin all over. But that's not the end of it. Once the judge has found the rationale and put it in semantic framework, he has to tell counsel. He has to tell litigants. Or she has to tell counsel. She has to tell litigants. And they discuss it from there. And how do they discuss it? Judges must remember that when they have discussions with themselves and discussions with litigants, that they are teaching that the law proceeds from a fair, rational, thoughtful, decent, respectful process in which if one person disagrees with the other, that disagreement is expressed and pursued and explored and refined by a discussion in respectful terms. And this is what courts must teach society. And it's urgent for the courts to do that today, because we are living in an era where our public discourse, our civic discourse, is hostile, fractious, disrespectful, not protecting the dignity of others. Judges, by teaching this process, also have the opportunity to teach the idea of respect for others and dignity. It was my role as a young attorney, to have a small solo practice with many small matters. This required me to appear before many judges in the greater Northern California area. And there were 4 judges, at least, who became my role models. It was inspiring to think that perhaps it would be possible for me to be like them. And there was another judge that was a negative role model for the way he treated the attorneys before him. And my resolution was never to do that to an attorney. Sometimes people ask, when you go on the bench, are you nervous? I say, no, I'm not nervous. Don't ask counsel that question and expect the same answer. Counsel is always nervous, standing at a podium looking upward. Not too long ago in Sacramento, it was my opportunity to visit a friend who was on the bench, trial court, and I went up the steps of the trial court, where for many years it was necessary for me to appear as an attorney, and my heart began to beat. I was nervous, which is fine, which shows respect for the process. So judges must always treat attorneys with respect and dignity. And this whole discussion of defining a principle and then letting people debate it applies to every judge, every day, in every case. Suppose a judge has decided, let's say a trial judge by himself or herself, has decided an issue 3 weeks ago. And an attorney comes, another attorney with the same issue. Does the judge just dismiss it out of hand? The judge, first of all, must tell the counsel what the judge intends to do, what the rationale is, and then in fairness, must listen to the counsel's response. Of course, judges want to be consistent. It's stare decisis writ small for a single judge. And of course, there's stare decisis writ large. The law has to be predictable. The law has to be stable. But sometimes judges have to understand that their initial ruling may not have been correct. And again, this is the duty of the judge, to ask himself, to ask herself always, why am I doing what I'm about to do? Now, this process of a thoughtful, dignified, respectful discourse is necessary if we're going to protect freedom. Freedom is not necessarily a natural instinct. A natural instinct is tribalism, where we identify with a group, identify with a family. Freedom has to intervene to modify that instinct, and this is free speech. Now, speech doesn't exist. Rights don't exist without responsibilities. And the responsibility we have with free speech is to listen to others in a dignified, respectful way. This is not happening in our day and age. In this court, which for 300 years has defended this process here in Philadelphia, must recognize this, and this court and all other courts must continue to teach. They must continue to teach that our freedom, the meaning of our nation, the destiny of our nation, is to pursue and preserve freedom. And the beginning of this is a decent, tolerant, thoughtful, rational, respectful discourse, among others. Courts teach this. You must teach this. We are in a time when we must seriously ask Is our democracy as strong as it once was? We are in a time when freedom and democracy around the world are on the decline, not in the ascent. Nations in the last 10 or 15 years are losing freedom at an astounding rate. Freedom isn't automatic. You don't take a DNA test to see if you believe in freedom. Freedom is taught. Freedom is pursued. Pursuit of freedom is a conscious act. And our courts must remember what this court knew 300 years ago, that the law is the beginning for protecting an order that allows freedom to exist. That's the beginning point. Our young people have to understand the history of this nation. They have to understand the history of this nation because it defines who we are. Of course we have flaws in our history. All humans have flaws. But it's our tradition to recognize those flaws, to cure them, and to move forward. Young people must know that the destiny of this nation, the definition of this nation, first was to have freedom for ourselves, and second, to give it to the rest of the world, and the rest of the world will take it only if we set the good example. And it begins here in this court. It begins here in all courts. This is what we celebrate today. We celebrate this as an opportunity once again to move forward and to have the best of our traditions continue. Philadelphia is a wonderful place because it's in part was midway between Boston and Williamsburg, Virginia. News could travel fast. Freedom could be discussed here as it was. And so Philadelphia is a marvelous place for us to remember on this 300th anniversary to recommit ourselves to the idea of freedom and to the ethics of freedom. Not long ago, there was a conference of ambassadors in Eastern Europe. I think 7 Eastern European countries sent their ambassadors and asked me to be present. And my request was that each ambassador should bring one judge from the ambassador's country, the judge that the ambassador and the people of that country respected. And so we had 7 or 8 judges from Eastern Europe discussing the state of the law. And afterwards, after the panel, after the discussion, it was my pleasure to meet with some young people. And a young woman raised her hand and she said, "There are 2 tragedies in my country. One is that the rule of law is slipping away. The other is that many know this, but few seem to care. We must care about the rule of law. We must care about the Magna Carta. We must care about the Constitution. We must care about the legal process. And we do this by celebrating this anniversary. Thank you so very much for inviting me."
Chief Justice Saylor, I have a question for you. We just heard Justice Kennedy say that state courts are supposed to be the defenders of freedom. You are the head of a large state judiciary. And I'm wondering if you can comment on the differences between state constitutions, Pennsylvania's in particular, and the federal Constitution.
Well, let me make several points. The first one, practical. The national Constitution is certainly an elegant doctrine, well conceived and crafted, short, 17 pages, but it's essentially a structural constitution. It establishes the structure of the government, creates the 3 branches, assigns powers to the branches, has an intricate system of power checking and power sharing, denies certain rights to the federal government as it does the states, grants powers. But state constitutions, on the other hand, many of which in the original colonies and then states preceded the national Constitution, and as the nation grew, have to deal with a myriad of other things that the federal Constitution doesn't have to deal with. For example, state constitutions to effect governance in the sovereign states have to deal with things like taxation. They have to deal with land use. They have to deal with political subdivisions. They have to account for municipal corporations. And as the country expanded and moved westward, they had to accommodate agricultural interests and mining interests and mineral interests. And then as the country further developed, they have to account for education within the states. So there are different types of documents in many ways. And as a consequence, state constitutions, unlike the national charter, are periodically, not frequently, but periodically revisited. Not that they're particularly easy to amend, and certainly it's difficult to amend the national constitution, but occasionally states will pause and take a look at their constitutional structure and adjust it. And to come back to Pennsylvania, we had our first constitution in 1776, and it's gone through 5 iterations. But the second point that I would make, and again I'm speaking of the original constitutions in the 13 states, I believe they all, pretty much all, included a Declaration of Rights embedded in the structural constitution. And that was, in Pennsylvania, it's Article 1 of our first Constitution. And it survived all these 300 years, well, not 300 years, but from 1776, essentially unchanged. And those set forth affirmative rights of a free people. People shall have the right to speak freely. The press shall be open. Unlike the so-called Bill of Rights, which was immediately appended to the national charter, and I think we all know the reason. There was a substantial debate at the Constitutional Convention. Do we really need a Bill of Rights? At the end of the day, it was decided they didn't, but they promptly saw during the ratification process that ratification would not succeed without a Bill of Rights. So, amazingly, James Madison promised them that if they would please ratify the Constitution, he would give them the Bill of Rights. And they took his word, and they ratified the Constitution. And the first bill in the first Congress was the first 10 amendments. But the difference between the so-called Bill of Rights and the Declaration of Rights in Pennsylvania's Constitution is, particularly take the First Amendment, it's couched not as an affirmative grant of rights, but as restraint on legislative power, particularly congressional power. So it doesn't say every man shall have a right to free speech. It says Congress shall pass no law abridging speech. Just a kind of an interesting aside as to pick up on Justice Kennedy's point that state constitutions are repositories of positive rights, that the persons that wrote the constitutions and adopted the Constitution believed existed from day one in a free and sovereign people. And the final point in terms of the difference between state and federal constitutions is it's an amazing fact that after 230 years and the explosive growth of the federal government, particularly after World War II and continuing to this day, the vast majority of standing law is reposed in the states. For the most part, the law of torts, contracts, real property, decedents of states, those things that affect the lives of people on a daily basis are matters of state law, superintended by state Supreme Courts. So they're amazing documents, state and federal, in their own right. We have an amazing system of dual sovereigns, each supreme in their own sphere, yet interlocking to form what James Madison called the compound republic of the United States.
So I want to pick up where the Chief Justice left off a little and go back to something also that Justice Kennedy said, which is that the power flows from the people. And I think one of the most interesting things for me is the affirmative grant of voting rights to people in state constitutions, as opposed to the national constitution, which has exactly the structure that Chief Justice Saylor was pointing to, which is the Supreme Court in the 1870s declared itself unanimously of the view that the federal Constitution confers the right of the franchise on no person. Instead, what the federal Constitution does is it says, well, if the state gives you the right to vote for the lower house of the state legislature, then you get to vote for Congress and for Senate. And then it says you can't discriminate on the basis of race or on the basis of sex or on the basis of age or failure to pay poll tax, but it doesn't give you the affirmative right to vote. That's given to you by the states. And the other most important thing, I think, for citizens and a free people is education. And again, the federal Constitution doesn't give you the right to an education. But I think all 50 states have in their constitutions the right to a free public education. And that's critical also for democracy, because if people don't understand, then they can't vote and they can't cast their ballots intelligently. And so the state constitutions are the backbone of what turns out to be our democracy in really, really important ways. And then, of course, even for the federal Constitution, a huge amount of how people experience the federal Constitution is in state courts. The Fourth Amendment, for example, is mostly about state prosecutions and the right to, not to have evidence taken against you. Miranda is mostly enforced in state courts. It's not enforced mostly by the federal courts. And so, for both federal and state constitutional law, the state courts are the major place where that law gets made and where that law gets applied to individuals in their everyday lives.
It would probably be presumptuous for someone who has been a federal judge now for 33 and a half years to try to hold forth on state constitutional issues. And beyond that, the Pennsylvania Constitution is the only state constitution I can claim even a shadow of familiarity with, having also been a state trial court judge for 4 years. But following up on both the Chief Justice's comments and Professor Carlin's, it occurs to me that the sheer number of cases, both civil and criminal, that are filed, tried, resolved in state courts make up so much more of the doing of justice in the country than anything that the federal judiciary does across the board. And so the constitutions of the various states certainly have enormous implications just in terms of the numerical reach that caseloads handled by state courts, which ordinarily have courts of general jurisdiction as opposed to the Article III courts in the federal system, which are courts of limited jurisdiction. Just one footnote that occurs to me, and this reaches back probably as far as when I was still a state trial court judge in Pennsylvania, and that is that there is sometimes the potential for state courts based upon their state constitutions, rooted in their state constitutions, to actually grant more extensive treatment to a particular right than what U.S. constitutional jurisprudence has afforded. And I do have just a faint recollection of some instances of what were Fourth Amendment cases where your court took perhaps what would be characterized as a more extensive view of Fourth Amendment rights than happened to be the U.S. constitutional jurisprudence at the time.
The federalism was the unique contribution to political theory made by the framers. The idea that you have more freedom if you have two governments rather than one, it gives you almost intellectual whiplash. I mean, how does this happen? But it's interesting. A separation of powers is extremely important. The framers could read about it in Montesquieu. They could see a faint resemblance to it in England, monarchy, lords, commons. And of course, they made separation of powers the essential structure of the national government. It's interesting, the Constitution does not use the word separation of powers. It does not use the word federalism. And these are two of its most important concepts. And the idea of the framers was that there's more freedom if the people are closer to the government, closer in any number of senses, spatially as well as intellectually, because it affects the lives of the people more directly. Federalism, of course, has changed, and you could go through it. It's really the spending of the federal government in the late 30s, the fact that we were in 2 world wars, the fact that we were a nuclear power, the fact that we are a commercial nation with interstate trade, which is deemed normal, the fact that we travel easily. And we want to be sure that this doesn't undermine the idea of federalism that the judge was talking about. In California, Professor Carlin, I think in some campaigns we have over 40 different ballot measures to amend the Constitution. And if the voter doesn't understand it, the voter will just vote no, usually. And this was the Hiram Johnson idea of allowing the people to amend the Constitution. And you can get an argument from scholars that it doesn't work well because it takes a lot of money to have a constitutional amendment that succeeds. You have to do a tremendous amount of advertising. But with the power of the federal government, particularly under the Civil Rights Action, more and more of what used to be state prerogatives are being taken over by the federal government. And it's very important that people understand the dynamic and the power of their Constitution. I won't spend a whole lot of time on positive rights. You're quite correct, Judge. Congress shall pass no law abridging freedom of speech. There should be no excessive fines or cruel and unusual punishment. In the 1980s, it was fascinating that countries around the world were developing written constitutions in Eastern Europe, in the Pacific, where I was spending a lot of time. And it never occurred to me that in my own day and age, people would be asking me about what should be in a constitution. It was fascinating. And one of the problems was with positive rights. You see a man on a steam grate who's cold in the wintertime and is poor and is begging, and he's there in his blanket, and you said, well, now, you know, there's a Constitution of the United States. You have a right to a jury trial, and you have a right to no excessive punishment. He said, I'm hungry and I'm cold. Of course, a decent government will attend to the needs of its people. But the reason, and all over Eastern Europe particularly, the draft constitutions had affirmative rights. The right to an education was one, right to housing, right to shelter, right to food. And these are basic in any decent society. But my advice, echoed by many others, was, but you can't put this in the Constitution because these are not judicially enforceable. Or if they are, the judiciary is superseding the legislature. And so the answer my suggestion in some places, they did it in Brazil among other places, was to put those in as aspirational rights, but not enforceable. And this is fascinating because we should always have aspirations to have a better society.
Professor Carlin, I'd like to turn to a subject that you've written about, and that is judicial independence. The audience has heard from prior panels about the Supreme Court of Pennsylvania's emergence from very uncertain, very tenuous beginnings to the modern independent judiciary that we recognize today. But you've written that judicial independence is not as simple as we might think it is. It's got a lot of factors. And because the question ultimately is freedom from whom and from what? And I'm wondering what you have to say about judicial independence and what threats you might see to what we recognize as, at least in a general sense, a laudable goal. Everyone wants judicial independence, but it's a lot more complicated than it seems.
Well, that's exactly right. And here I want to pick up on when Justice Kennedy was talking about how judges go about deciding cases. He says the first thing to ask yourself is, who am I? And so this question of what judges should be independent from and what they should be independent to do, it's both a kind of negative liberty and a positive liberty for judges, right? So if you think about, there's some forms of judicial independence that are completely, I think, non-controversial. Judges should be free from fear that they are going to be killed or imprisoned. I mean, and this is something that ties in again with one of the things that Justice Kennedy was saying about the loss of freedom around the world and the decline from a kind of high watermark, that there are countries in which judges fear they're going to be put in jail based on what they decide. No judge should feel that. So judges have to be free from that. Judges should be free from pecuniary interests in their cases. There's a famous U.S. Supreme Court case from many years ago, Toomey against Ohio, where there was a judge who was paid if he issued a search warrant, but not paid if he didn't issue a search warrant. Well, you can kind of see what the incentives are there. So judges need to be free from that. The question, though, of should judges be free from their own backgrounds, nobody gets named a judge because they were raised in a bubble and never lived out in the world. So judges have backgrounds, they have experiences. I think, at least, judges who have been criminal defense lawyers have an experience that judges who've never been criminal defense lawyers don't have, judges who've been prosecutors do, judges who've had individual clients versus judges who've only worked for the government before they came in. So the question, should judges be free from their background? Harder question to answer in some ways, because people were picked in part to be judges because of their background. On the other hand, we don't think judges, for example, should be, especially not judges on inferior courts, inferior in the sense that they're district courts or intermediate courts of appeals as opposed to Supreme Courts. They shouldn't be free from the law as announced by the judges ahead of them in the judicial hierarchy. You don't want to say, well, I personally think that this decision by my Supreme Court was wrong, so I'm just not going to enforce it. We've had judges in California, Justice Kennedy will know about this, who announced, I don't believe what the California Supreme Court said, I'm not going to do what they said, and there have been problems like that. So the question of, judges shouldn't be free from the law, they shouldn't be free from the organized, orderly hierarchy of the judiciary. They should be free from pecuniary consequences. When you have an elected court, you have to ask yourself, should they be free from what some people would think of as electoral retaliation? There are famous cases of state Supreme Courts where justices have gotten defeated for re-election because of their view on the death penalty or the like. That's a hard question, because if you're going to have an elected judiciary, you have to ask, well, what is it that the people should be looking at when they vote for judges? How accountable should judges be to the law, to the hierarchy, to the people's views? That's why I think it's actually a really hard question once you get past the sort of judges shouldn't be afraid and judges shouldn't be, judges shouldn't have a monetary stake in what they're doing. Once you get past those, you get into, you want judges free from some things and free to do other things, but conversely, you also want them a little bit constrained. I mean, there's a culture of being a judge, and it's different than being an advocate or being a politician, and you don't want judges to feel free in that sense in the same way that the people are free or politicians are free.
Okay, well, we've covered judicial federalism and judicial independence. I want to talk, Judge Smith, about another very, very important aspect of the judiciary, and that is judicial administration. I can't think of a person better to talk to than you. You have been the Chief Judge of the Third Circuit Court of Appeals, the Chief Judge of the United States District Court for the Western District of Pennsylvania, and by the way, the Administrative Judge of Blair County, the Blair County Court of Common Pleas. But we hear complaints that justice is too slow, it's too expensive, sometimes it's not consistent and equal. And I'm wondering, with you really as a member of the Judicial Administration Hall of Fame, I don't think anybody has the credentials you have. Certainly in the Third Circuit in history, I don't think anybody's served as both Chief Judge of a district court and the Third Circuit, what you think about complaints like that and how the process of judicial administration might be improved.
Well, it's hardly a subject that is very demanding intellectually, I have to say that, but it does have practical implications that are important. Some of those criticisms, I think, are valid, and we have all heard them, and all of us who are judges have responded to them in various ways. But it really is a cost and delay which become the very brief litany of complaints, the enormous cost, especially on the civil side for discovery, and the delay attendant to trials and getting cases to a point where they're prepared for trial on both the civil and criminal side. So administratively, we have, I think, a tremendous responsibility to move cases along. It is something that individual litigants see and experience, and sometimes courts become mired in backlog, which create problems not only for the individual litigants, but really for the reputational value of an individual court. I don't know, Chief Justice Saylor may remember the days in the 1980s when I ended up almost being drafted to take over some administrative responsibilities in the Blair County courts. And that was an interesting experience, I must say, because I have ultimately Chief Justice Nix to thank for that. Just anecdotally, our court, which was a small court of just 4 trial judges, had just an amazing streak of bad luck, of deaths, illnesses, and some other problems where our judges fell very far behind. I was a relatively new judge. I didn't have the backlog problem. And in an interesting example of federalism, I suppose, some criminal cases that had had huge delays, interestingly, in the disposition of post-trial motions, resulted in habeas cases being filed in the federal court, actually attacking ultimately the state court, which led to an informal conversation, I understand, a conversation to which I was not privy, between the then Chief Judge of the Third Circuit, which was ultimately getting these cases, and Chief Justice Nix, in an effort to try to work out a real problem here and avoid a clash of the federal courts and the state courts. This led Chief Justice Nix to conclude that he needed to take some action with respect to our court. I was called. He said, I would like you to take over the administrative responsibilities of your court, which was enormously difficult because the president judge was a very, very good friend of mine and a neighbor as well. And I kind of demurred and said, well, what if I don't? And the chief responded, well, then I think the results for your court would be a lot more embarrassing, which I concluded meant we'll get somebody from the outside. And I understood the bind that he was in. So I said yes, and it was a tremendous effort of cooperation between the bar, between lawyers, especially on the defense side, prosecutors and defense lawyers, but private practitioners as well. I mean, what we did was have an active effort to settle cases, get cases pled out, and the result of it was that the federal case was mooted out and got settled for attorney's fees, essentially. But I use that experience, that anecdote, for several reasons as an example of some of what we've been talking here, of the interplay of our federalism between cases at the state level and cases that implicate federal jurisdiction, as well as what can be accomplished in a collegial sense, where judges work together and where bench and bar work together in an effort to clean up a problem. And in this case, it was a terrible backlog that not only made its way into federal court, but also managed to garner a great deal of negative publicity, as one can imagine, and a lot of complaints from litigants who were rightly dissatisfied with the delays. That was a teaching experience for me, and it probably animated in many ways my future actions as especially a trial judge, but as a judge at the appellate level as well, on the need to adjudicate promptly, not hastily, but promptly, to realize that cost and delay are present in every case, and that everyone expects that judges are going to be careful, of course, but they're going to be diligent, and they're, where possible, going to be speedy as well.
Justice Kennedy, you served on the United States Supreme Court for 30 years, under two Chief Justices, Rehnquist and then Roberts. I'm wondering in that time what changes on the court, or perhaps more generally in the judiciary as a whole, stand out to you as especially notable?
Justice Byron White once told me that every time you have a new justice, you have a new court. That's the dynamic. Not too long ago, Justice Breyer ended his tenure as the junior justice when Justice Alito was appointed. Breyer was the junior justice for 11 years. For 11 years, we sat at the same table in the same room. And when we had discussion, which were wonderful discussions, in many respects, I knew that you knew that I knew that you knew what was going to be said next. But that enabled us to begin discussing principles much more quickly. And incidentally, Breyer was a junior justice, and from the standpoint of court administration, we don't do much, but the junior justice is in charge of the cafeteria. And Breyer was the cafeteria justice for 11 years, and so the first meeting where we had Alito, I made the motion, and Nino seconded it, that we have a rule that the second most junior justice be. So we and on the Supreme Court, we don't do much court administration. The Chief Justice has to do that. But court of administration is tremendously important. And you said what has changed? Really, in large part, the society has changed. The Supreme Court is much more front and center in the public mind than it was formerly, because its jurisprudence is concerned with rights, duties, responsibilities, directives that affect you as a person in your personal life. And so the court has to recognize that it must take new steps to show how independent and how fair it is. And we are in an era, to my considerable regret, in which partisanship plays such an important role in the discussion of who should be a judge. There are many factors that go in to determining who should be appointed to a judge. Judge Smith and Chief Judge Smith and Chief Justice Saylor know that. And there's a danger that the court will be seen as partisan, even if it isn't. The judges, though, shouldn't have to work hard to rise above partisanship. And I'm concerned that that's happening because of the way in which the political branches discuss these appointments. The justices on the court now are very conscious of this. They're very conscious of being open to the ideas of the other side, to thinking anew about what there should be. And it's you don't know when you're appointing a judge, or the judge doesn't know what issues are going to rise 10 years from now. And so the judges, I think, are more conscious now of the fact that they have to be, that they have to adhere to the values that we always thought of as part of the independence of the judiciary.
I think Justice Kennedy is absolutely right that society has changed in important ways. In the 20th century, especially the second half of the 20th century, there was a huge overlap between the two major parties in the United States. They both had liberals and conservatives in them. Starting in about 1995, 96, the two parties began to move apart from each other. So there's now no overlap in Congress.
Polarization.
The polarization's much huger, whereas when I was growing up, the Northeastern Republicans were to the left of the Southern Democrats. The two parties have really pulled apart in various ways. And the upshot of that is that everybody views the Supreme Court as a battleground now. If you look back to the confirmation of, Justice Ginsburg on the left and Justice Scalia on the right, I think the vote for Justice Scalia was 98-0. The vote for Justice Ginsburg was something like 92-6. There is no way today that you would ever see that kind of consensus, and that plays out in important and damaging ways because people don't view the court as independent from the political process. The other thing that's changed dramatically is how people become Supreme Court justices. If you go back to the court that decided Brown against Board of Education, for example, how many years of judicial experience did those justices have before they became Supreme Court justices? The modal number was 0. So you had Chief Justice Warren, who had been, not only had he been governor of California, but you will know that, what's the best trivia fact in some ways about Chief Justice Warren as governor of California? Both parties nominated him to run as governor.
He won in the primaries.
He won the primaries for both
there
parties.
Was no runoff. Right.
He won the primaries for both the Democratic and the Republican Party, right? You had people who had been senators and congressmen. You had people who had been mayors, right? I think, you had the last person with that kind of experience to go to the Supreme Court is Justice O'Connor, right? You had people who had practiced outside of the Amtrak corridor a lot. Those things all have changed, and it's changed, I think, the way the justices think about the court, and I think it's changed the way people think about the court, both in politics and out.
And not just the justices. What we have seen is what you're describing percolate down into selection of the inferior courts, too, in the federal system. We've seen the process of both selection and confirmation of lower court judges, and certainly over the last 20-some years of Court of Appeals judges and occasional district judge nominations become highly politicized, interest groups becoming very, very much involved. There's money there. There is money there for interest groups. There is highly politically charged elevation of issues attached to lower court judicial nominees as well. So the process has changed in that way also.
On the upside, it's fascinating to me how many young people are willing to go on the judiciary where they have to make a long-term financial sacrifice. But they're doing it because it's a way for them to contribute to society and to the whole idea of freedom. We are just really often impressed by the qualification of someone who has a marvelous private practice but will leave to go on the bench. So we still are attracting people who want to be in the judiciary in order to preserve judicial independence, in order to show that the concept, the idea, the profession, the tradition of judging is rewarding.
Interestingly, and to make the point that Justice Kennedy made and is very concerned about, and rightfully, since we're here in Philadelphia and we'll be at the Constitution Center soon, but they had a seminar not too long ago, and the speakers decried the loss of what we call civic virtue, which of course comes from the ancient Greek philosophers, most notably Aristotle, and I think simply means, in simplest terms, the dedication of citizens and their leaders to the common good. And do you think, Justice Kennedy, that's in some way missing today, the dedication of leaders and the citizens to the common good, not self-interest, but the common good of the republic.
I think my concern is indicated in my remarks, that young people don't know the history of this country, that young people don't know the destiny of this country. They think only in terms of what's important today. They don't understand that we have a long tradition of preserving freedom for ourselves and attaining it for others. And we simply must once again begin to think about what this nation must mean to the rest of the world.
We did not plan this, but this is a perfect lead into my final question, Professor. And just so you know, the judges on this court right here have 108 years collective experience. I actually added that up. An amazing sample to talk about these very issues. But the rule of law is among our most cherished values. But, you know, as I think we're describing, past is not necessarily prologue. Each generation has to renew its commitment to the rule of law. And maybe, you know, that's the way we bridge this divide that you perfectly described that's happened over time. And as a longtime law professor, how do we instill a renewed commitment to the rule of law that might tie together all the disparate groups and interests that you've described, and value the rule of law, which would bring us together and maybe bridge some of these divides?
There's a line of James Baldwin's where he says, you know, not everything can be solved, but until you face it, you can't solve anything. And I think understanding our history in a deep way is very important for that, because we have seen this before. If you look at the end of the first Reconstruction, we went from, for example, in the 1880s, 80% of black men in the United States voted in the presidential election, to by the early 1900s, 4% of black men in Louisiana could vote. You know, we have had cycles in our history, and understanding those cycles is important to understanding where we are today, which is we are at a point of polarization, at a point of economic inequality that looks back to where we were during the Gilded Age. And we saw tremendous civic unrest in the United States then. So one question is, how do we get beyond where we are? And some of that depends on people having confidence in the courts. Confidence that cases will be heard fairly, confidence that judges have not prejudged how a case is going to come out before they hear the evidence if they're in the trial court or before they read the briefs on a court of appeals. We have a huge amount of, you know, it's not just delay in the judicial system, but it's huge numbers of people with unmet legal needs because they don't have lawyers. You know, we've done a reasonably good job of providing lawyers to criminal defendants. Not a perfect job, but a reasonably good job. But when you think about civil litigants, you know, how can those people have confidence in the rule of law if they don't feel that they can get their day in court?
You get a appointed counsel if you have a traffic ticket, but if you're being thrown out of your home by the landlord, you have no counsel. And there are some programs in Southern California that are making great headway in this. But Chief Judge Smith was saying the same thing. And we really have to solve the problem of representation in civil cases. And you stated it very well. This is a week in which it would be my preference to remain here in Philadelphia and not have to go back to Washington. This is the week in which the justices were stunned by a leak of a written proposed opinion, a first draft. And this leak was a cowardly, corrupt, contemptuous act. Did it hurt the court? Yes, because we are so proud that our independence consists of the tradition of talking just among ourselves to have reasons why we decide the case. And the temptation often is to look to the bright side of things. And because of the discord this has caused, this is maybe not a happy time to look for the bright side of things, but it is a time for us to recommit. You know, the law learns from bad acts. All those books on the wall that you see are filled with bad acts of persons. And we take a bad act and we prove it. And it means that every court, your former court, Chief Judge Smith, your former court, Chief Justice Saylor, every court in the country must take this moment to recommit itself to the idea of absolute judicial independence, of absolute integrity in its deliberations, of absolute commitment to a rational, thoughtful discourse that does not turn into a public debate, and where the justices are free to take the time they need to figure out what the reasons for their decision are, whether those reasons are fair, and then present it to the public to see if it commands allegiance.
Thank you. Thank you, Justice.
Okay, we'll continue the live discussion now. I first want to recognize that former Chief Justice Ron Castillo has joined us. Welcome, Chief. Chief Judge Smith, I actually want to ask you about hazing on the Third Circuit and see if anybody's the cafeteria justice, but Justice Kennedy ended with very powerful words about the consequences of the leak. And so, you know, at the end, there wasn't a question posed. We had asked him on the side whether he was willing to talk about it. And, you know, and he was, and you heard what he said. So he said that it has significant consequences for not only the process of confidential deliberations, but also ultimately judicial independence. And I'm wondering, what your thoughts are as a longtime federal judge on the consequences of things like that in courts.
Please excuse my use of notes in my response, something that I virtually never do, but I want to be very, very careful in addressing this matter. Justice Kennedy quite rightly called the leak of the draft opinion a cowardly, corrupt, and contemptuous act. I would also call it malicious. It doesn't matter how or why the leak happened or the purposes, for purposes of our discussion, it doesn't do any good to speculate as to by whom. But it was, as much as I hate to use the dark phrase, an inside job, just that. And the person or persons responsible had to know that the leak would do damage to the institution. Discussion of the inner workings of the Supreme Court of the United States is well above my pay grade. But I do worry about how the messy episode will impact the openness of communications among those justices and between justices and law clerks. As to the world that I inhabit as a judge on an inferior court, I am concerned that this has been a body blow to judicial institutions across the board and how they are perceived by the public. We tend to overlook the reality that most Americans are woefully uninformed about the judicial function, both structurally and how we judges go about deciding cases. Anecdotally, over the years, I've been disappointed in encountering citizens a number of times, college-educated citizens, who have remarked to me that my boss is the Attorney General of the United States. That's what we deal with. That kind of public ignorance has dangerous implications for state and federal judges and for the rule of law itself. Leaks coming out of the two political branches of government are not exactly unique. Will this recent episode, implicating as it does the sanctity and confidentiality of the decision-making process, fuel what I believe is an already growing public perception that judges are simply politicians in robes? I hope not. process, process. If we are about anything in the judiciary, it is about process. Confidential internal deliberations, especially on a collegial court, are an enormously vital component of process. I hope that this recent unpleasantness will not serve as an invitation to those who fail to understand and value our deliberative process as an invitation to at least attempt to lobby the court or other courts. I also hope that all who value the rule of law will see how the leak and some reactions to it have put the justice's personal security at stake. The last few years have presented both the Pennsylvania Supreme Court and the courts of within the Third Circuit, presented us with unprecedented challenges, a pandemic and a contested presidential election. And I'm very proud that we all kept the wheels of justice turning, state and federal judges alike. It was critical during those times that we do our jobs and that the public see that we were doing our jobs. It's for others to grade us, but I'm personally satisfied that both court systems passed the tests that they confronted. Finally, courts in recent years have become increasingly engaged in robust civics education initiatives. Bar associations have as well. Through coordinated and collegial efforts of all of us, we should be able to put this recent episode of a leak behind us through vigorous public education efforts and by just doing our jobs as they're meant to be done. Thank you.
Professor Carlin, I'm interested in your perspective on this. You clerked for Justice Blackmun. You've argued in front of that court many times. By my count, you've won at least 2/3 of the cases you've argued there. And you've also written and spoken a lot about the court. So I'm interested in, again, taking Judge Smith's marker that we're not concerned with how or why the leak happened for this purpose, but I'm wondering what you think about the implications.
So, you know, it's a little bit like the famous story of Zhou Enlai being asked what he thought about the French Revolution and saying, well, you know, it's kind of too early to tell. And I think it's too early to tell here because a lot depends on what happens over the rest of this term and then over subsequent terms. If the court turns into an institution in which leaks happen with some regularity, the court will be treated just like another political branch of the government over time. And if the justices feel that they can't circulate opinions within the building without those opinions leaving the building, that's going to change fundamentally the dynamic within the court, because huge numbers of opinions, I don't think I'm saying anything out of school here, but huge numbers of opinions change quite dramatically between when they first get circulated and when they come out of the building. Somebody says, I can join your opinion, but you've got to take out these sentences, or I'll join this part, but not this part. Or another justice writes a concurrence or a concurrence in the judgment, and the majority changes to hold 5. If it then starts to look to the public as if public reactions change opinions from the first draft to the ultimately published draft, that will dramatically, again, change how people's view of the law is. So it's very hard to know at this point what the long-term effects will be. And of course, it's not just that there was a leak in some case, it was the kind of case in which there was a leak that makes a profound difference. You know, from my perspective, I would like to think less about the leak and more about the people who are going to be affected by the court's ruling, whatever the ruling is when it comes out in June, because there are millions of people who are going to be affected by this in various ways. The question, I mean, this goes back to something we were talking about a little yesterday about judicial method, and I know Chief Justice Behr, you say, method, you know. But judicial method matters, and one of the things that we talked about yesterday is stare decisis. And if it turns out that the Supreme Court has a series of cases in which it fundamentally changes the law of the country, that will have effects on how people think about the court as well. So this is just a piece of a much larger picture. It's a piece of a picture in which presidential candidates announce, here's my list of people I might think of to put on the court, and announce, if you elect me, here's what the Supreme Court's going to do. Even judges and justices who are deciding cases in the way that, in their conscience and their independent view, that's how the case should be decided. It's hard for the public. This is, I think, part of Chief Judge Smith's point. It's hard for the public, if they don't understand all of that, to recognize that even if the president promises you that the people he puts on a court are going to decide the following 6 cases in a certain way, he's not deciding that, and people shouldn't vote for or against a candidate on the grounds that he's telling them what the law is going to be. If people don't understand that, then they are going to view the court as, you know, I'm going to name the following people to the FTC, and we're going to change how we deal with baby formula. I'm going to appoint the following people to the Supreme Court, and here's how we're going to deal with 6 or 7 major issues. That is a real danger. And I don't think we've had a period in American law that I can think of, certainly not in modern times, where there is this threat to judicial independence that's of a different kind than we've had in the past, which is the loss of public confidence in the fundamental integrity of the courts, and that's a real danger.
All right, I want to stick with the theme of political branches of government, but change the topic just a little bit, Chief Justice Saylor. You spoke very eloquently on the video about the difference in state constitutions, especially Pennsylvania's, and the federal constitution. And now I'm wondering about the difference in how perhaps state courts and federal courts interact with their respective legislatures, because we heard a lot today, especially on the prior panel about from the state Supreme Court justices, about challenges perhaps and budgetary constraints, et cetera, in dealing with their legislatures. So what is your perspective, having been the former Chief Justice of a very large state that is politically diverse also?
Well, putting aside the interaction that was discussed earlier in some panels about the funding issues, which is always a dynamic between courts and legislatures that are dependent on, for their substance, on general state appropriations. I wanted to take a more intellectual view of some differences between the way state and federal courts must deal with their legislative counterpart in the actual making of legislation academically. And it falls on the courts. It's another difference perhaps between the state or the federal constitution and state constitutions. As you know, in terms of the passage of law, the work of the legislature, the U.S. Constitution says very little. Revenue bills have to start in the House, and both houses of Congress have to pass them, and the president signs them. But in Pennsylvania and many other state constitutions, there's more. There's actually a section in the Pennsylvania Constitution, not just on the legislature as the branch, but on legislation. And within that section are certain process restraints on how the legislature can act. And 2 of the large ones are that in Pennsylvania and many other states, a bill can only have, it has to maintain its original purpose throughout the legislative process, and it has to pertain at the end when signed it has to contain only a single subject, very much unlike the national constitution. And that, of course, those amendments were typically put into state constitutions in the 1800s, because of various legislative excesses. But the real purpose was to prohibit what they call log rolling, so you couldn't trade off different items to secure the passage of legislation, which you can do at the federal government. It's, in the federal regime, it's done every day, but in Pennsylvania, you can't trade a reservoir in Pike County for a fairground in Fayette County, even though you could do that at the national level. The second, but the final point, or a subsidiary point is, that's nothing that a court is delighted to have to do. In other words, the last thing a state court wants to do is intrude on how a coordinate branch does its business. You say, look, get the laws passed and we'll look at them after they're passed. But we are compelled by constitutional necessity to decide those cases, and that's typically a form of tension, depending on our decision. Second thing that is contained, the second item in our state constitution, to think of another one, and again in many state constitutions, is prohibition on special laws, special legislation. You can't, unlike the federal regime, you can't have a law that applies only to one person, so you can't grant citizenship to, but the U.S. Congress could grant citizenship to Professor Carlin. Our legislature can't do it. Again, legislative excesses. We talked about the ability to amend state constitutions to reflect contemporary issues and realities, and they again were placed in there because of legislative overreach. The legislatures in the 1800s were passing special laws, forgiving debts, granting monopolies, granting divorces. The third area that comes to mind in the difference in approach to construing or dealing with challenges to legislation, legislative enactments, is in the area of the non-delegation doctrine. And that is constitutionally based in both the state and federal constitution, in that it sounds in separation of powers. It's grounded in the vesting clauses, which vest all legislative power in the Congress and in our instance in the Pennsylvania General Assembly. But there, the constitutions are the same, but the interpretive position of the respective courts is different. And I know we're running short on time, but I can tell you, it seems to me, and Professor Carlin could certainly tell you more, that it's essentially been a dead letter in the U.S. Supreme Court since the 1930s, and I don't know one case where the piece of legislation was stricken as violative of the non-delegation doctrine, whereas in Pennsylvania and many other courts, it's a viable doctrine. And only a handful of years ago, in 2016, our court, in the Philadelphia School District case, struck down a legislative assignment to the school district as violative of that very principle, that the legislature can't delegate without sufficient guidance its power to a coordinate branch of the government, be it the executive or the legislature. So those are three differences, and there may be others that occur to me as to the court involvement in what our coordinate branch does by way of fulfilling its function.
Could I just say one thing that's, I think, more practical than doctrinal? And we had a delegation doctrine case from our clinic up at the Supreme Court, and we got a couple of votes for it, and didn't really go anywhere. I mean, and that is, there's a profound difference between the relationship of state Supreme Courts and state legislatures and federal courts and Congress, which is, you know your state legislatures. Many of you came from the state. I still remember the many years of Judge Jubileer, Senator Jubileer, right? You know, so there's an understanding, and I think therefore a kind of respect, a mutual respect and admiration between state legislatures and state courts in a bunch of ways. For a lot of federal judges, the only experience they've had with Congress, and this is true for I think for the members of the Supreme Court, is their confirmation hearings, which is Congress at its absolute worst. Right? It's people reading questions they don't understand, not hoping to get answers. it's a terrible experience, and it plays out, I think, in an attitude towards the product of Congress that's very different than the attitude towards the product that state Supreme Courts view from their legislatures, who are their neighbors, their friends, the people they see, the people who went to the same law school with them, yada, yada.
I wish I could have said that and not have to worry about impeachment. Thank you.
I mean, you know, I did the commentary for one set on the Lair News Hour of a Supreme Court hearing, and I never want to have to sit through an entire one again. It's just, words fail me.
Well, I'm actually disappointed that we're out of time, unfortunately. And Mr. Mongaluzzi will say this a lot better than I will, but this has been absolutely tremendous. And thank you all.
So I say this to our court. Pennsylvania Supreme Court is the crown jewel of America's state Supreme Courts. And you have added luster to an already glittering crown. So on behalf of the millions of citizens of Pennsylvania, I wish Pennsylvania Supreme Court a happy 300th birthday. May you have many more. And may we, thank you. And may we all see you tonight as we celebrate and commemorate this historic moment at the Logan. Thank you.